what?
I have housing and a job now. We're no longer homeless.
That's fantastic. When did that happen? You got that taken care of? Huh?
Less than 24 hours after my fiance bonded me out, I called a farm, Donahue Farms, and got a resident farm hand job.
Fantastic.
Job came.
I didn't hear you.
Michael Dewberry.
All right, Mr. Dewberry, you were charged with theft by shoplifting. The bond is $2,000. As a condition of bond, you cannot return to the Dollar General located at 6489 Terra Boulevard in Jonesboro. Do you understand that condition of being granted bond? Yeah, are you currently working anywhere?
Actually, for myself.
Okay.
I'm unemployed.
Yes, you're working, and no, you're not. All right. Based on that, I've approved your application for an attorney. Do you have any questions?
No.
Do you have questions?
Yeah, I want to know.
All right, I have to thank Rosalind Duke for that hand job clip, which was absolutely fantastic. This is Alyssa's fault, I think, as is some other stuff. And everybody sent me the clip yesterday of the crazy woman in 3B, and she's less interesting than the interplay with the judge and the two attorneys.
In the process of knowing that I'm the first victim of a national state of emergency, I am the reason why there was declared a national state of emergency, because life-threatening ballistic components were discovered in my torso.
Okay, so Mr. Dewberry, we'll take that up. We'll take that up on another day. All right, not today.
I was just trying to see if I can get. I was trying to see if I can get a SOB.
No, not based on your criminal history. I've already evaluated that. Take care.
Come on, Dewberry.
I don't steal.
Dewberry.
Okay, thank you.
What's my court date? What's
Did you tell me?
I see you wasn't listening. I told you I did. He wasn't listening.
What is it?
It's on October the 29th.
October 29th.
Mm-hmm. Yes.
8 o'clock. Come on.
All right, next, Mr. Edwards.
Day.
Today is the 3rd.
Mr. Lewis, you're charged with one count of driving with no motor vehicle registration. Mr. Lewis, there is probable cause for the charge. I'm appointing the public defender's officer to represent you, and I'm asking that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Lewis. At this point in time, he's going to have no contest. Understanding he'll be sentenced to 10 days in the county jail. He'll have 2 days jail credit, be a $400 fine, and he has waived his, he signed a waiver, waived his right to jury trial and call witnesses.
And Mr. Mitchell's that agreeable with the state?
It is, Your Honor.
Mr. Lewis, did you hear that agreement? Mr. Lewis, is that the plea that you would like to enter?
Yes, sir.
How much credit did you say, Mr. McDaniel?
2 days.
2. Mr. Lewis, I'm going to accept your plea of no contest then. The reason you're getting a jail sentence is because according to the complaint, you got a warning for this exact same thing a few weeks earlier. I believe it was a few weeks earlier. Actually, not even that long. Yeah, it was actually a few weeks earlier. The exact same thing. And the allegation is you just continue to ignore that and continue to drive with an unregistered vehicle on the roadway. That and the fact that you're already out on bond is why you're getting the 10 days. But Mr. Lewis, anything else you want to make sure I know about it? Anything else you want to tell me before I impose your sentence?
He does want to tell you something, but I don't know anything about him being on bond anywhere, though.
Yeah, he is on bond out of, according to his sheet from the jail, he's on bond out of Geneva County, Alabama. That was also a factor in the jail sentence.
Yeah,
but anything you want to tell me, Mr. Lewis, I'm glad to listen.
No, sir, I'm having a problem out the law. They wanted me to sell drugs to that. I shouldn't have no problem out no law.
Not really.
I know, but that same officer right here, they gave me this ticket. I got Ann Hatcher, Judge Hatcher's daughter helping me. She told me to sit down and take this. This is a hard go right here. Look where I'm at. You know, I work every day. Now, when he stopped me on that truck, Miss Ann already had talked to him and told him to deal on that truck. And I think he'll see me cross the store while getting fuel going my truck. That's what he decided to get out and stop me in the middle of the road and all this here. I don't know. I feel like I have to do something. Who do I have to see to get this to stop? Because you can talk to Geneva County Sheriff. Look it up. You can go talk to Geneva County Sheriff up yonder. His name is Perez. And he can tell you that he told Ann that I would not witness.
Who do I have to talk to get this stopped? Oh, that's good.
The method to try to involve me in this stuff.
What charge do you have pending in Geneva County? What charge you on bond on?
Well, there were two fans trying to set me up and put dope in my truck, and now they try to back it out because I'm not with that stuff, so I should not have
What
any
is
problem
the
with
charge? I can't understand you. What charge are you on in Geneva County? That's what I want to know.
They said they caught drugs in the truck, nigga. And they
Okay,
also
so drug
ain't got
charge.
the-
Just drug charges. That's what
Okay.
you got charged.
All right, Mr. Lewis, I'm
Yeah,
gonna accept your plea. The other thing on your criminal history is you had this same charge a couple of years ago too. And I think that may have been in the state of Alabama. I mean, look and make sure I'm not wrong.
I'm having a problem with the law, but I should have a problem with the law. I should have no problem with the law. Should have no problem.
I know I saw another charge in here for
Give up. I'm
same
about to give
things.
up. I'm about to give the fuck up. I'm about to give up. I'm about to give up.
Mr. Lewis, what do you do for a living? You said you work every day. What do you do?
I work for Alan Henderson down here at the Babcock. I've been cutting trees, man. I've been doing everything. I lost every goddamn thing behind this bullshit. I'm
It's okay,
tired.
Mr. Lewis.
I'm tired. I'm
right.
fucking tired.
You know,
I'm tired.
Mr. Lewis, stop and just listen to me. Stop. Be
Tired,
quiet. Just listen,
man.
okay?
I'm tired.
Yeah, you might want to mute that. Mr. Mitchell, if he's working every day, I don't necessarily have a problem giving him a purge. Any objection to that from the state?
We have no objection.
All right, so what I'm going to do, Mr. Lewis, you've already entered this plea. I'm going to add a purge sentence on there. What that means is you pay the court costs and fines, you'll be released, even if you haven't finished the 10 days in jail. If you're unable to pay the court costs and fines, then you would finish the 10 days in jail. If you pay that today, you'll be out today because this is the lowest degree crime we have in Florida. I just need you to not drive that truck until you get a tag on it. Mr. Lewis, you pay the $400, you'll be released. You will get to use the phone in a few minutes to try to pay the court costs and fines. Do you have any questions? Mr. Lewis, do you have any questions?
Have questions?
No, sir, I'm just tired of all this.
All right.
You'll get to use the phone shortly, sir.
Yeah, you mentioned that.
And that's why I'm here all the time, because
All right, this is
you
weird.
never know when they're going to arise.
Yes, we've got someone in the midst of a mental health crisis, and that's like the least of the problems that are going on in this hearing.
We are on the record, and the defendant is not here yet, but I'm going to call the case. Title of the case is People versus Janelle Ann Anthony. The file number is 241775FY. We have a host of people here. We have the entire public defender team headed by Keith Stickley. We have Ross Truckee, who's been appointed to represent this defendant, substituting for Paul Gibson. We have prosecutor David Marvin. This is an emergency motion for, I'm not sure exactly what, modification of the bond. My understanding is the defendant was quite agitated at the time of her arrest. In fact, I'll tell you what I know about it. I was arraigning another person, and I called over and they brought a young woman and they said, well, it may take a minute. We've got an unruly person coming from Three Rivers. And I think I heard a little ruckus in the background. Well, that person was Janelle Anthony. I was at a meeting yesterday with the undersheriff and he said she was still quite agitated. She's charged with assault with intent to commit great bodily harm, resisting and obstructing a police officer, ethnic intimidation, 2 counts of assault and battery. So we're about to bring her in. I asked the bailiffs to tell her that Judge Middleton wanted to see her and bring her in. So we'll see how this goes as I bring her in. And
There is.
for you. Hi, Middleton.
Good afternoon. Miss Anthony, can you hear me?
Yeah.
Hey, Deb, good to see you. Yeah, this one's ugly. This whole time I thought, it'd be nice if Deborah already took office here. That was literally my primary thought.
Okay, this is Judge Middleton.
Hi.
Hi, I wanted to talk to you. I've got a bunch of people here at the court with me. Mr. Keith Stickley, the Chief Public Defender, is here. Your attorney, Mr. Ross Truck.
The defense attorney, in my opinion, is also extremely annoying. Not Keith Stickley, the other one.
He is here. And prosecuting attorney David Marvin is here. Janelle, I don't know if you remember me, but I remember you from when you were.
I know my dad. I went to school with your son Alex. He was
yes, I remember.
He was a good boy. I liked him.
Well, thanks. He's still a good boy. He just turned 40. All right. You're charged with some very serious charges.
Yeah, they were.
Assault with intent to commit great bodily harm, resisting obstructing a police officer, ethnic intimidation, and 2 counts of assault and battery. The magistrate set the bond in the amount of $10,000 cash or surety, and Mr. Truckee made a motion, and he wants me to review that bond.
Thanks, Mr. Truckee.
Your Honor.
Yes.
I had the opportunity, sorry to interrupt, I had the opportunity to review the video from yesterday, the arraignment. And the same sort of thing that happened yesterday from my point of view is happening now. I don't know if she's aware of what's going on as she sits there. I don't know if she's on the page. I don't think she heard a thing he said. And I know at any time, anybody could make a motion for competency. And I would suggest that she assess for competency.
All right, Miss Anthony. Janelle. All right. Janelle, I'm going to let you go back to your cell. Brandy, you can take her back. All right, thank you. Well, that did not go well. Started all right. David, I don't think you helped anything. I was establishing some rapport and then it all sort of went sideways. But
I don't agree, respectfully.
Well, I guess you don't have to.
I can't believe that came out of his mouth. It is so tone deaf. It is so off. The judge is obviously very irritated with him, but holding it back. And then he says, I respectfully disagree. Oh, yes, you're the only genius who could see that she might be having mental health problems. We all see that. He was trying to proceed with an arraignment, you goof, to the extent possible. If not, fine. But we all know that. You didn't say anything that anybody didn't know.
I had given the floor to Mr. Truckee to make his motion, and you said, I don't want to interrupt, and then you interrupted.
Your Honor, may I say something else?
Yes.
I was looking at the computer screen. I don't know what you're looking at, but I saw somebody who had her head turned away from you and did not hear words you said. And I don't know if you're looking at the YouTube
I
monitor
saw
or
the
what
same.
you're looking
I saw
at.
the same thing you saw.
I would like to inquire, Mr. Marvin.
All right. Well, first of all, let's back up. You made this motion. I'll read it. You don't cite any authority. You just made a motion. The reasons for the modification of the bond are failure to effect a.
Thank God the voters of that county rectified this situation. Because I can't believe he just said that again.
Proper arraignment on the defendant within 48 hours. There exists an unreasonable delay due to the ill will of the custodial officer during the arraignment hearing. The defendant was under threat or coercion during the arraignment, and the officer's actions jeopardized her constitutional right to make statements freely. Magistrate Autumn Kiefer probably was doing the same thing I'm doing, trying to do the best she could with a mentally ill defendant. And the unreasonable delay is not unreasonable because the delay is due to the mental illness of the defendant. And Mr. Marvin, I think, is on the money that we need to probably have a competency evaluation sooner rather than later. So, Mr. Truckee, what were you asking me to do?
I was asking you to find that the arraignment that was offered and is being tendered as an
Thanks,
arraignment
Leslie.
within the 48 hours was not a valid procedure, not due to Miss Anthony's unruly conduct or mental illness, but due to the conduct of the corrections officers that were present in the holding room with Miss Anthony. Twice the taser was directed at her head.
Well,
She was
look back
directed
up. What's your authority for this?
under MCL 764.13, 764.26, and People v. Cipriano all address the need for this 48-hour period. And it's United States and Michigan constitutions.
All right, well, let's take yesterday off the table for a minute. I just attempted to do an arraignment myself. The bailiffs were gentle with her. She was okay for a minute, and then she disassembled before our eyes. So whatever just happened was not as the result of conduct of the corrections officers. I asked the officer how she was doing. They said she was calmer today, but she had been crying all day. She's obviously suffering from severe mental illness. Problem in today's world is we can't tell how much is mental illness and how much is methamphetamine or both. The current configuration of methamphetamine helps create schizophrenia. So I don't know if that's what we're dealing with or she just is schizophrenic. The charges are very serious. Assault with intent to do great bodily harm. The booking information indicated that she jumped on some lady's back and broke her collarbone and said a bunch of racially charged hate stuff and fought with the officers, and it was a bad situation. So what you're asking me to do is essentially give her a PR bond or just discharge her?
I'm requesting that she either be granted a PR bond in this case with the understanding that she's on bond in a circuit court case, and that PR bond may not mean her immediate release. But I think in this file, she was denied due process by failing to be arraigned and failing to be afforded the ability to meaningfully participate, even though her participation isn't going to be terribly meaningful. A taser was aimed at her during the arraignment. She was directed how to answer the magistrate's questions. And I don't think that in any way that can be found to be an effective process.
All right, well, the one we just did was,
You know, a taser being aimed at her might have been necessary. Did you see her behavior right now? I get it. You're a defense attorney. You want to do it, but he tries to sleaze this. He tries to say, no, I don't want her to go for competency, but I want her to get a PR bond. What? I understand you're trying to help her, but, and what? Let her walk the street?
she's posted bond in the circuit court. As far as I know, there's been no motion to revoke that bond. I don't have the authority to revoke it. She's pled guilty, so she's no longer presumed to be innocent, so she's not entitled to a bond, but she has a bond and she posted it. Now that was, she pled on the 24th of September, and this incident occurred on September 30th. So I'm not sure what happened between the time she pled in circuit court and the time she got arrested in Three Rivers.
I would indicate, Your Honor, I'm in possession of a complaint regarding her conditional release from Officer Dibble. Due to this alleged conduct, he's seeking that in a circuit court case, and it's suspected it would be dealt with promptly.
All right, well, I'm gonna deny the motion for PR bond.
I did have an alternative request if Your Honor would hear it.
All right, what's your alternative?
It may be based on the conduct during the arraignment, request that she be held at a different facility pending trial. It appears that it's unsafe for Miss Janelle Anthony at the jail.
All right, so you make an oral motion on the fly for me to remove her from the jail. So I'm not gonna grant that either. I don't know. I have faith in our jail staff. I know
that would be a
all of
no.
them. I knew the two ladies in the video. I don't know what happened yesterday. I know what I just saw. But the fact that we're gonna get a competency
I was about to tase her based upon what I saw. That's all I'm saying.
evaluation is gonna greatly delay this, and she's gonna be sitting there. So I don't know if there's any evidence that she's being mistreated presently. I did talk to the undersheriff about her yesterday. And couple issues. For the last several years, we've had Covered Bridge as our mental health liaison, jail diversion specialist at the jail. That contract ended September 30th and a new contract began with Pivotal. And frankly, we've had some bumps in the road. I had asked someone for some help with Aaron Brown. And I made 2 requests last week with no response. Got a response on Lisa's last day, September 30th. And then I sent an email to the director of Pivotal saying, will someone please help me with this guy? He's sitting in
someone misses Covered Bridge
jail and he's got some serious mental health problems. And I haven't heard anything back. So right now, mental health is Pivotal, our county mental health, who decided to not call themselves Community Mental Health, but Pivotal, is connected to Miss Anthony. According to your petition or somewhere, Vicki Merrill's, it's in the bond information form, from Pivotal is presently supervising her.
Pitiful is what I like to call him. Okay, I got nothing against Pivotal. I just want to help pile on here.
She was apparently capable enough on September 25th to enter a guilty plea in I guess it was no contest plea in circuit court, and Judge Stutzman accepted it. I'm not sure, as I stated a minute ago, what happened between then and now.
My God, it's like I'm running their stream. Speaking of which, I did vlog on the wrong channel today. Another apology for that. I'm sorry.
All right. Do you have a position regarding Mr. Marvin's request for a competency evaluation?
I'm not able to take a position on competency at this time. I was appointed to this afternoon. I've got to meet with Miss Anthony before I can speak.
Oh, really? This is so frustrating. Judge Milton is so calm about it, but I'm not going to take a position on competency. I'm going to come in here with my pants on fire, telling you that my client needs to be let out on the streets today because of all the horrible things that are going on. But I'm not going to take a position on competency. Are you kidding me? As if we care what your position is.
On it.
All right, I'm denying the motion to amend or change the bond.
And the only further request I have, Your Honor, is that this court review the video of the arraignment.
As I said, I'm not worried about that arraignment. I'm worried about the one I just did.
I understand.
So I'll say I would set a $10,000 cash or surety bond based on the conduct, based on the fact that she was on a felony bond.
Oh my God. All right, that's all we have. Sorry about that. So then I then I'm surprised that my own clip ended, and then I muted myself. So let's get her back up there. Let's get her back up there. Let me see what do we do here today. We've logged on the wrong channel. Apparently, I look like death warmed over because everyone's telling me. And then I screw up this stream and mute myself. Other than that, it's flawless execution over here at Law Talk with Mike. Well, there you have it. I mean, it can happen, but I really couldn't figure out which attorney was more irritating in that case. And that's saying something, because they were both pretty bad. All right, there you go. That's what I had. That's the clips I had. I also already had a court appearance, and I've got a deposition. Oh yeah, I'm a busy boy. It's not it's not all walking around drinking Pilsner Urquell and whatnot. Oh, I also got chewed out. I guess I should say that now. I also got chewed out pretty hard by a Czech on the last stream. He wants me to say Czech Republic, which is fine. Hell, I go back to Czechoslovakia. I get it, but the way I read it and everything I booked was Czechia. I mean, I don't know. I don't know how to pronounce it. That's what's on my tickets and stuff. There you have it. There you have it. So good times. That hearing, like I said, it was interesting because yes, she's got issues. I don't know if it's meth induced or that. I don't know. That's for the mental health professionals to figure out. But clearly, she was out of hand. That much is clear. Although Mr. George thought he was so smart pointing this out, absolutely blind to the fact that he's stepping on what Judge Middleton was trying to do, which was solve the real problem and get her and have the arraignment. But okay. So anyway, the interesting thing was that as crazy as she was the smallest part of the problem. we knew where she was coming from. It was the attorneys and their really sort of awkward positions in that it was something. You have days like that. All right, I'm gonna see if I can get a little nap before my deposition. Thank y'all for coming out. I appreciate it. I'll see y'all soon.